Welcome to Law for Life with Georgia.
Welcome to Law for Life with Georgia, where attorney Georgia Konstantakis brings nearly 3 decades of Wisconsin legal experience to help her community stay informed, protected, and prepared for whatever life brings. I'm Shamika Rhymes, and today Georgia's going to cover protecting aging parents with proper estate planning in regards to the power of attorney and guardianship. Welcome back, Georgia.
Nice to see you again, Shanika.
Great to see you. Well, Georgia, how does a standard power of attorney differ from a durable power of attorney? And why is this distinction the single most important factor for an aging adult?
Yeah, a durable power of attorney is powerful. It basically goes into place at the beginning, from the start to even during incapacity. When you've got a standard power of attorney, if that person becomes incapacitated, that standard power it just gets eliminated. So it makes sense. And when I'm doing estate plans, I always offer the option of a durable power of attorney because it is an extremely powerful document. And in my documents, I also put a guardianship clause in there. So that way we don't have to go to probate court to establish guardianship of an individual. You are pre-choosing who you want to be your durable power agent as well as your guardian if something happens to you. So there is a distinction, and definitely the standard power of attorney is garbage. It's useless. It really doesn't do much for you. It gets extinguished upon incapacity. So,
well, should a power of attorney be effective immediately upon signing, or is it only a spring into action once incapacity is proven? What are the risks of waiting?
That depends. I've got clients who come into the office and their wife or husband is deceased, and they've got a couple of kids, and maybe they may not necessarily trust their kids 100%. When you're giving someone an immediate power of attorney, it's called a durable power of attorney. Mm-hmm. It's literally effective as soon as the ink is dry. So tomorrow, even if you're not incapacitated, they could take that document and go and pull money out of the bank. It's extremely powerful, and it works wonderfully if you trust those people who you've appointed to act as agents. The springing power, what happens with that is it only springs and activates into place if the individual is incapacitated and cannot handle their own financial affairs. So there are 2 powers, springing and durable. And I always say to clients, it depends on how you feel. If you don't feel safe, if you feel like you're giving your rights away immediately, then do the springing power. Now, there could be complications, and here's the reality. Mm-hmm. You have to make sure that 2 doctors say that you're incapacitated. That's where it could be complicated, and then you're powerless. So there's that waiting period of getting 2 doctors to examine your parent or your loved one and to determine that they're incapacitated. So you can't move as quickly with the springing POA, but you can with the durable because it's effective immediately. So banks, like I said, banks tend to, they like the durable power because then there's nothing that they have to do, no due diligence on their part to say, hey, have you activated the incapacity clause? So in times of emergencies, it does make sense to go durable. And in most cases, I choose durable for clients, or I nudge them in the direction of choosing durable.
Is it risky for a parent to have only one type of POA? And what specific scenarios could arise if they lack a healthcare proxy but have a financial POA?
In the state of Wisconsin, and a lot of people don't know this, in our state, if you are married to someone, you do not have any powers to make any healthcare decisions. True story.
Wow.
Because of the HIPAA laws and that the way that they've created it, there is a privacy. So a spouse cannot make those decisions at all. You need to have a POA for healthcare in order to activate that, and then you'd be able to make those decisions. So there are two separate POAs. There's a financial and a health, and you need both.
Okay. That makes sense because, just thinking about my own situation with my parents, I'm able to talk to their doctors because they don't tell me everything because of a
Right.
healthcare
Yeah.
POA. So,
Doctors will not share information under the HIPAA laws.
Mhm.
They could get sued
Mhm.
if they share information with spouses, with children, unless they've got a POA document in place.
yes, they made me send that over before they said
Yep.
one word to me. So, absolutely.
Yep. Yep. And it's funny because you can pay the bill,
Mhm.
but you can't talk to them about or authorize or talk to them at all about their medical condition. So it's
Right.
kind of comical when you see that. Oh, we'll take your money, but we can't tell you anything.
Right.
So, but that's why you got to protect yourself. You got to get both of those documents. That's something we do on the jump. I don't even, when my clients come into the office, I make darn sure that they're getting what's known as a 5-pack. It's a will, power of attorney for healthcare, power of attorney for finances, living will, and a HIPAA release. And based on their financial situation, then I'll jump to a trust. But in most instances, they're at 100%, they're getting the 5-pack.
Legally speaking, how do we determine when a parent has crossed the line from being forgetful to being legally incapacitated?
Oof, that's tough. That is a tough one. Usually it requires a doctor to personally examine that person and make the call of whether that person is incapacitated. Um, you know, just because you said the person is forgetful, it doesn't necessarily mean that they have a full-on diagnosis of dementia. It has to be a doctor evaluation to make that determination. And sometimes you need multiple doctors. In our state, you need 2 in order to fully execute a POA document. Otherwise, the court's going to decide. And usually in a situation like that, the court gets involved and they appoint a physician to do a medical exam of that individual and to determine incapacity. So there are, unfortunately, it happens and it happens a lot. In fact, I can tell you a story. I had a lady who was found trapped between 2 cars in the parking lot of her condominium. She slipped and fell on ice and was sitting there almost dead. And she was found by one of the other, unit owners. And then she was rushed to the hospital. She had no documents whatsoever, no POA for health, no POA for finance, nothing, no will, nothing. They had to amputate her leg. They saved her life. And then they determined after she came to that she was in fact incapacitated completely. She had severe stages of dementia and she was living alone. So another church parishioner had to get involved, stepped in, and had to get court appointed as a guardian of this woman. So it was a very tragic situation because she had no family at all. Everybody, she never got married, no kids, no brothers and sisters. The bloodline stopped there, and she had assets. So in that situation, the assets are going to go to the state unless somebody comes up and says, I'm related. So it was pretty tragic. But guardianship cases take a really long time. It is not a 1, 2, 3 process. You have to go through a hearing. You have to take classes to become the guardian. It's not just a 1, 2, 3. It's a 6 to 9 month process by the time you are appointed and actually the court approved. And sometimes you'll get loved ones that will try to object to that person acting as guardian. And if you have that situation, that case can drag on for years. And then you've got the person sitting in the hospital room with absolutely no direction. So you can only imagine what it does. It's a tragedy.
Guardianship is often described as a legal last resort, but what makes it so much more invasive and expensive than having a POA in place? And it sounds like a lot is involved, what you just explained.
Yes, you need a physician's report to say that the person is in fact incapacitated, and that person would have to testify in court if necessary and get court approval. So the court, you're going to have a judge sitting there listening to the case and making sure that the person has good intentions, that they're not going to be someone that's going to take on the position just so that they can basically squeeze out all the inheritance. It's got to be someone who's fit for the position.
Well, can a court-appointed guardian ever override the decisions made by a previously named power of attorney?
Yeah. Yes. Yes. A court-appointed POA can definitely override and revoke the original POA that might be in existence. Those scenarios are kind of tough because it's usually the situation where the POA that's previously appointed isn't doing a good job. They're really not taking care of their loved one or the person. I mean, you may be a friend, but they're not doing the job. And then if you have a guardian who takes over, that guardian now, it's like that person. They step into the shoes of the individual that requires the care and the guardianship. So, yeah, those are tough situations, but we've run into it a few times where there's conflict, there's abuse. Maybe that person who is a POA is not just abusive to the individual, but they also might be taking substance abuse, drugs, alcohol, whatever the case might be. So in that instance, they get kicked out, and then the court steps in, takes control. It could have a court-appointed guardian, and that happens all the time, where there's a court-appointed guardian.
Well, we've seen that in the news with some celebrities too, getting appointed guardianship, over them without naming names. But that's been a whole interesting thing to watch, in the media. But I wanted to switch gears to many parents wanting to name all their children as co-agents to be fair. If there's multiple kids and they don't want to leave somebody out. So what are the practical nightmares of this approach? And is there a better way to ensure transparency?
Yeah, it's, you know what? You can only try educating clients so much. Honestly, it is an absolute mess when you've got two people appointed as co-agents because you're at a stalemate. Yeah. And in that scenario, one might be saying, pull the plug. The other one's saying, no. We don't want to pull the plug. Keep them alive. So there's no cohesiveness as to what decisions should be made. And in that situation, it's a gridlock. And I always say, no. There's only one sheriff in town. And that person needs to be appointed. You can name that other child that's secondary, but there will be one sheriff. And that person's going to call the shots. Now, getting back to the abuse, if you think that there is abuse, then the other kid can go in and swoop in and say, I'm establishing guardianship on my mother because you're not doing a good job. The only reason that you wanted to be appointed was so that you can abuse the situation and take all of mom's money. So in that situation, and that abuse does happen more than you know. Can't tell you how many times you hear the bank account got cleaned out. They used it for personal stuff and not for mom's care. That happens a lot, unfortunately. But you would hope that you raised good children and that they're not going to do that and there's not going to be the infighting. But in that situation, it can become a nightmare. And the other thing is, when you're doing POAs for finances, then you need everybody's signatures. That's another collective nightmare, or you need all the people to be in the hospital to communicate with the doctor and make those decisions. That can really be a hardship, getting everybody in one room at the same time, especially if you've got kids who live across the country.
Yeah.
In that situation, I always say, have a local person. Don't appoint Susie who lives in Taiwan. You got to make sure they're accessible. Somebody who's going to come in at the jump and take care of the situation. So I can't stress the importance of that. So that's in a nutshell.
Well, as we wrap up, how often should these legal documents be reviewed, and what specific major life events trigger an immediate need for an update?
Yeah, there's a lot of things that could trigger it. We call them life events such as divorce, a birth, death. Maybe there's like a family conflict of some sort. Those are all kind of triggering events. Marriage, that's another one. You may have appointed a mother or a father to be your POA, but now that you're married, you want to put your wife on or husband. I mean, there are circumstances where you want to change who the fiduciary is. And if you want to do that, it makes sense to do it upon those triggering events. Again, the big one is, your kid might move. It might move from Wisconsin to, say, Indiana, and now they're 4 hours away. What do you do in that situation? Well, I'm not going to have this person, I'm not going to put them in a tight spot where they have to drive back 4 hours in order to make a quick medical decision when you need to make the decision immediately. So in that instance, I say it makes sense. Choose family members, but choose them where they live close by. So that way you don't have that issue. Another big thing that we see is just family conflict. You might no longer get along with that child who you chose. Things happen. You may want to disinherit them. If that happens, it requires us to do an absolute change in the will. And then if there are any POA documents that have appointed and named that person, we got to change all those documents. So all of those things, those are triggering events. Anytime you want to make any changes, you're going to have to come back and see us. Typically in those cases, we do charge just hourly. We don't, because it might just be a quick thing that we've just got to put in the computer and change the names. It really just depends on the situation. Sometimes we have to do a brand new document because everything has changed. So it really just depends. So, we do charge a flat rate for a 5-pack, and then we also have a flat rate for a 5-pack plus the trust. We call that the 6-pack. So we have the 5-pack and the 6-pack in that instance. So, and then the other big thing with making sure in your trust that it's fully funded. That's a huge one. A lot of people miss that step, and then you're off to probate because you forgot to put one asset into the trust. So that's definitely something that I say to clients. If you acquire more property, that's a triggering event. Call me, because then that is a change of your financial situation. It requires us to make amendments to the documents.
Well, thank you, Georgia. This has been so helpful and informative, and a reminder to check my own triggering events and make sure I'm up to date on that, actually, and my parents.
Yeah, absolutely.
Well, thank you so much for joining us again. And that's it for today's episode of Law for Life with Georgia. To learn more about attorney Georgia Konstantakis and Konstantakis Law Office, LLC, visit konstantakislaw.com. Thank you for listening, and be sure to subscribe, share, and leave a review if you found this episode helpful. Thank you again, Georgia.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.